welcome to another episode of RC Retirement. For this episode, I'm going to talk about a recent case that I'm working. I was recently asked to testify in a court case. That was rather interesting. In this particular circumstance, neither side of the case, neither lawyer nor the judge really knew much of anything regarding military retirement, and I was asked to come in and speak regarding some of the particulars about it, namely how concurrent retired and disability pay worked. So I was talking about how those particular items worked in regard to this particular case. This was a divorce case, and I was asked to testify in regard to how it would work with this particular service member and this ex-spouse. And what I want to talk about for this particular episode is namely a question that came up during that testimony. The question that came up from one of the lawyers was regarding a 20-year letter. The question asked was, can a 20-year letter be revoked? And fortunately, I had predicted that question would be asked and was ready for it. So I had the particular piece of law, of federal law, in front of me and was ready to read it off. So here is the answer to that question, and I'll go into a little bit about that as this episode progresses. So actually I'll stop and I won't read that yet. So we all know that in order to get a 20-year letter, you have to have a minimum of 20 qualifying years, meaning you've got to have a minimum of 50 retirement points and a minimum of 20 years with those minimum of 50 retirement points per year. So we know you've got to have that. The number of years you have for pay is irrelevant. It's the number of qualifying years for retirement that matters. That gets a lot of people all twisted out of shape because they'll say, I've got X number of years for pay. Look at my LES, my leave and earnings statement. And a retirement services officer such as myself or another RSO out there will have to say that doesn't matter. It's the number of qualifying years that you have that matters. The number of years for retirement that matters. It's not the number of years for pay. And that gets a lot of people angry. So, moving on, once you have 20 years for retirement purposes, then a notice of eligibility for retired pay at age 60, or now they really should drop the age 60 part since there is a reduced retirement age law in effect. So we'll just say notice of eligibility for retired pay. That notice of eligibility is issued by whichever branch of service happens to apply for the service member. And everything is good, right? Well, that is when the question comes up. Can that letter ever be revoked? Well, let's look at U.S. Code, Title 10, subsection 12.7, 38. And that particular subsection is limitations on revocation of retired pay. I'm going to read it word for word, and then I'll translate it into English. Alright, so subparagraph A, which is the only part that I copied. After a person is granted retired pay under this chapter, or is notified in accordance with Section 12731 Delta of this title that the person has completed the years of service required for eligibility of retired pay under this chapter, the person's eligibility for retired pay may not be denied or revoked on the basis of any error, miscalculation, misinformation, or administrative determination of years of service performed as required by Section 12731 Alpha 2 of this title, unless it is resulted directly from the fraud or misrepresentation of the person. Alright, so let's back up and translate that into simple English, as I like to do. So what this is basically saying is once that 20-year letter has been issued, it can never be revoked unless it can be proven that the service member somehow gained that letter as a result of fraud on his or her case. Direct fraud on the case of the service member. If it turns out that the letter resulted from an administrative error or miscalculation or some other fault of the case of the branch of service, that does not matter. The letter has been issued and it is still a permanent document now. Once that letter is in the hands of the service member, it is permanent. That is why it is such an important factor at the level at which the letters are generated, that there's such a quality control check, or there's supposed to be. When I was at that level, we checked and checked and checked again, over and over. We checked these people over and over again to make sure that they were indeed eligible. And every now and then we would find one or two that were not and would strike them from the list. So, we would make sure that people who were not eligible for a 20-year letter did not get them. And it would turn out that they would be eligible for the next cycle, the next month, or the next year, or whatever. And it was just, they're not eligible right now. So we wanted to be sure that people who were getting the letters were actually due for them now. Because once we sent those letters out, they could not be called back. They could not be revoked. And that was a common misconception with some of our officers and senior NCOs. Well, if there's a mistake, we'll just revoke it. No, sir. No, Sergeant Major. We can't do that. It's a permanent document. Once it's in the record, once it's in the soldier's hands, in the service member's hands, we cannot call it back. It is a permanent document. And that is something I had to say to these judges and these lawyers, who somehow had it in their heads that the 20-year letter was a temporary document that could be revoked. I don't know where they got that idea, but I read this portion of law to them and translated it into English, which, of course, being lawyers, they were able to do that themselves, and cleared that up for them. So that and a few other bits of law made the case suddenly make sense to them. So that was a good day for them. Now that was something that I thought, that actually made me realize that I've never actually talked about this topic, or if I have, it was only in passing. So I thought that I should make an actual episode regarding this particular topic and pass that information on to you. Now, if you want a more succinct version of that section of law, you can go to the Army Human Resources Command website, which says regarding issuance of the letter, once your notification letter is officially issued to you, your eligibility for retired pay based on non-regular service cannot be denied or revoked on the basis of any error, miscalculation, misinformation, or administrative determination of years of service performed, unless these resulted directly from the soldier's fraudulent misrepresentation. Administrative errors, such as award of too many points, can be corrected, but your eligibility to the associated retired pay cannot be withdrawn. And I'll put a link to that and the section of law in the show notes for this episode, just so you have access to it. Now, one thing to keep in mind, just because a letter cannot be revoked, if it does turn out there is an error in your record, let's say that you actually don't have the right number of qualifying years. Let's say you only have 18 qualifying years. When it comes time for the branch of service to pay your retired pay, then they are only required to pay based on the qualifying years and number of retirement points that you have. So keep that in mind. They're only required to pay based on the correct record. You still have the notice of eligibility. You still have that document that says you're eligible for retired pay. That cannot be taken away. But you'll only be paid based on what is officially in your record. So keep that in mind. And here is what was being brought up in that particular court case. Without bringing up names, I'll mention what was going on with that case, because there are others like it, and you should be aware of that. I mentioned this was a concurrent retired and disability pay case. The member was being told that he was not eligible for concurrent retired and disability pay because he did not have the minimum number of qualifying years. Well, he had a 20-year letter. And even though his retirement point statement said that he had 18 qualifying years. Now, there is another retirement point statement, the particular 20-year letter that he has states a higher number of retirement points. Each branch of service formats their letter a little differently. His states a retirement points total that is higher than the point statement that shows the 18 qualifying years. So during my testimony, I suggested that he do a retirement points audit. And the funny thing that came out of that was the judge then ordered both parties to contract me and split the fee to do an audit on his service history and find the missing retirement points and hopefully increase his retired pay. But let me back up and get to the point of that. So his retirement points showed 18 qualifying years. He has a 20-year letter. He has a VA disability rating of 100%. The minimum for CRDP is 50%. And he is over the age of 60. Therefore, according to the law, he is eligible for concurrent retired and disability pay. He has all the required pieces. And that was what was in contention. So, even the branch of service told him he had to have either 20 qualifying years or a 20-year letter, and he had the 20-year letter with their own, letterhead and high officer's signature on it. So that could not be held in contention. So that was an interesting little bit of debate. So that is going to be resubmitted after the retirement points audit is complete. I actually believe that after the audit, sufficient points will be found to show that he did have 20 qualifying years as well. He had several breaks in service, and I think enough points will be found to show he had 20 qualifying years. All right, so that is enough for that. Enough rambling, I think, for now anyway. So thank you for being a part of this audience, being a part of this episode. I do appreciate you spending your time with me. And I ask that you come back next time and spend some more time with me. If you would like to support my efforts, then please go to patreon.com/rcretirement and sign up to support me on a monthly basis at any particular level that you choose. And until next time, thank you for being here and thank you for your service. Have a great day.
If you liked what you heard on today's episode, then please go below and give it a thumbs up, and be sure to subscribe to this channel. Also, please let other people know about this channel and the information it can provide for them. If you have questions or comments, then please have no qualms about posting them in the comments section below. Please remember the RC Retirement YouTube channel and the RC Retirement website are not recognized or endorsed by the Department of Defense, the Department of Veterans Affairs, or any other government agency. The information presented in these resources are for entertainment and informational purposes only. Also, the content of either of these resources should not be considered financial or legal advice. Please consult with your own legal counsel, accountant, or financial planner before making any decisions based on what you have learned here. As always, thank you for watching the RC Retirement YouTube channel.